SJC-13331, City of Chelsea, New England Police Benevolent Association, Local 192.
Okay, Attorney Treadway, whenever you're ready.
Pardon me. Good morning, Madam Chief Justice. Good morning, Associate Justices. May it please the Court. My name is Stefan Treadway, and I represent the City of Chelsea. This action is the City of Chelsea's request to vacate the award of an arbitrator below, finding that Chelsea was subject to compulsory arbitration of a 2021 dispute with the New England Police Benevolent Association under the 2016 through 2019 contract that Chelsea had with its Teamsters Local 25, which had been the previous collective bargaining representative of the 911 dispatchers. As a consequence, this case raises the question of whether or not a collective bargaining agreement and the arbitration clause within it can survive the termination of the collective bargaining relationship that gave birth to it.
If it can, what's the impact of disclaimer of interest in January of 2020?
So if it could survive the termination of the relationship, the disclaimer of interest wouldn't really have an impact. The argument the city is making is that the disclaimer of interest is the method by which the agreement was terminated. And therefore,
but that's not the way.
Or the relationship was terminated, rather.
But okay, the city of say there was no change in union representation.
Assuming there was no change.
Assuming there's no change, wouldn't this still be in there? Still hadn't gotten a new collective bargaining agreement. This would still be enforceable, right?
It would.
So, are we punishing a change in union representation by saying that this can no longer be arbitrated, meaning that we would be interfering with unions' ability to change representatives?
We are not.
Why not?
Just as employees have the right to reject their previous representative, a union can reject a group of employees. So the mechanism by which it does that is a disclaimer of interest. It can walk away with a relationship with a bargaining unit.
I have no doubt that this union, the old union, shouldn't be doing this because we've changed union representatives. But for example, all those employees in Chelsea, do they have the same terms and conditions they had under the collective bargaining agreement? Meaning that their salary is determined by the collective bargain, their wages and hours, their workplace conditions. Is all of the rest of this contract being enforced? That's a yes or no.
Not because of the contract. So it's similar to the case before.
It's just because out of the goodwill of the city?
No, it's a requirement.
What is required? Yeah.
Section 10A5 of the Massachusetts Labor Relations Act and Section 8A5, the cognate federal act, the National Labor Relations Act, an employer who has represented employees, whether or not there is a contract, cannot change terms and conditions of employment without bargaining with the representative. This is actually very similar to the case that you just heard. It's a similar, we would have to go through decisional or impact bargaining.
Aren't the grievance and arbitration provisions the same as the rest of the contract? Meaning they stay in place until you reach impasse, and then if you reach impasse, you can make changes or not. But isn't this all kept in place while you negotiate?
No, there's a distinction between hearing grievances and arbitrating them. So under Lytton, the U.S. Supreme Court decision under the National Labor Relations Act, the employer is obligated under the Collective Bargaining Act to meet with the union and negotiate over grievances, but it's not obligated to arbitrate grievances absent an agreement to do so. So both under federal law and under state law.
But the old agreement bound you to arbitrate.
Exactly.
That old agreement is still in effect. You're telling me that it's still in effect on everything, including the grievance, but not the little arbitration provision?
No, I'm arguing that the agreement, the Teamsters agreement, ceased to be in effect in any way at all when they disclaimed interest on January 8th of 2020.
Despite the, I think maybe about a year earlier email from the city solicitor?
So the agreement was extended past its nominal termination date, which was June 30th of 2019, because both the city and the Teamsters had indicated a desire to negotiate new provisions for the contract. So that extended, by virtue of the Evergreen Clause, the contract during the period when negotiations were pending. However, on January 3rd of 2020, I believe it was, New England Police Benevolent Association filed a petition to represent the Chelsea dispatchers. Once Chelsea became aware that there was a so-called question of representation, we had an obligation to not deal with either union. We had a legal obligation to not deal with either union, not sign a contract with the Teamsters, not sign a contract with the New England Police Benevolent Association until the will of the employees as to who is going to represent them in negotiations became clear. So if that didn't terminate the extension of the Evergreen Clause, whose manifest purpose is to protect the contract while negotiations are pending, the reaction of the Teamsters afterwards in disclaiming interest, walking away from that relationship, certainly did.
But again, I get that the Teamsters are out of the game, but somebody else has stepped into their shoes.
Not until April 16th, though.
Well, but again, the contract is perpetuated when they give that notice. It's kept in place because we don't want sort of the world to, we don't want to penalize people from changing unions and losing all those benefits.
So I'm sorry to interrupt you.
No, go ahead, because it's hard. I get it.
Yeah, I don't want to lose my train of thought. I
Okay,
apologize.
go ahead. No, go ahead.
So the contract is kept in place by virtue of the Evergreen Clause to protect the contract while negotiations are pending, not to protect the employees in their interests as far as who's going to represent them. So the party to this contract is the Teamsters, not the employees.
No, the party to the contract are the employees covered. We don't care. We care about the people who are covered by it. They're the ones who are protected by it. The union negotiated it for them, but they're beneficiaries of that contract, right?
We certainly care about our dispatchers. I don't want to give the wrong impression as far as that goes.
But they're not left in the. They're not left in a void. They're that. I mean, I understand your argument that somehow the arbitration clause, like the space shot, that gets dropped off while the rest of it keeps flying up. That's the part that
So that is not my argument. The contract in its entirety terminates with the end of the relationship. What stays in place when New England Police Benevolent Association is certified on the 16th of April, several months later, after the Teamsters have disclaimed interest, what stays in place are terms and conditions of employment, so wages, hours, terms and conditions of employment. Again, very similar to the vaccine mandate case you just heard. We cannot make changes absent decisional and or impact bargaining.
That's what I don't understand.
Absent the contract.
If the wage and hours maintain, the terms and conditions, wage and hours, vacation policy, those all maintain in the interim period.
Once the NEPBA is certified. So during the period where there is no representation, they are not.
Okay,
but we haven't made any changes.
Right,
so
but that's my question. Yeah. So if during that interim period, could the city of Chelsea say to the dispatchers, you don't get any vacation leave anymore?
There's other protections in place.
That's what I'm asking.
Other than that, so they would have the same rights to vacation that unrepresented employees have in general, But beyond that.
I'm just wondering what it is about the arbitration provision makes it a standalone versus other terms and conditions of employment.
Under both federal and Massachusetts law, a party may only be compelled to arbitrate a dispute if it's agreed to do so. So arbitration is a creature of agreement. There must be an agreement to arbitrate. Absent that, no party can be compelled to arbitrate.
What's the legal mechanism that makes the other terms and conditions of employment be maintained during that interim
The
period?
employer's duty to bargain when employees are represented. So, for example...
But who are they bargaining with? You don't know who to bargain with.
Right. So once the Teamsters disclaimed interest and until the New England Police Benevolent Association was certified, there was no duty to bargain because there was no, they didn't have a representative. That said, Chelsea made no changes. There's nothing in the record that suggested we did anything. And an employer would be,
So they didn't
would be absurd, very foolish for an employer to make significant changes in the context of a union campaign because they'd be subject to the
But we
argument.
know they can't do it during the union campaign. The question is, though, once they change representatives, do you start completely from scratch? Meaning, because essentially you're saying sort of they're doing it out of the goodness of their heart once they change representatives. But I don't think that's true because otherwise then there's been this dramatic loss of protections when you change union representatives, and then you're punishing the change of union representatives, aren't you?
And that's what the town of Watertown prevents, right?
I would say that it doesn't, and I am acutely aware that the author of Town of Watertown is present on the bench today.
It doesn't mean it was rightly decided.
no.
So, and I'm not arguing that
it was a
wrongly
long time
decided.
ago.
So I am not suggesting that Town of Watertown should be reversed at all. I think it's
Go ahead.
entirely consistent with previous cases that have said that rights, and this at the federal level, I think this is Nolde versus confectionery workers, rights that had accrued, that had arisen under a previous collective bargaining agreement can be enforced subsequent to the termination of that collective bargaining agreement. So for example, in Town of Watertown, which was also a case of discipline, the employee was disciplined and discharged, I believe, the day before the change of union representation, and the decision merely allowed the subsequent union to enforce those rights that had accrued prior to the change in representation. And there's language in Town of Watertown that I think, to my mind, strongly suggests it wasn't intended to be extended.
While you're looking for that, are you saying that the Watertown case does not stand for the proposition, big picture, that changes in unions doesn't void the CBA?
I think that's not true. So I think Town of Watertown, for example, let me find the quote briefly. It's just going to take a second.
The good news for you is we're not bound by the town of Watertown.
So I think that there's no need to touch Town of Watertown. I just think we just want to avoid extending it because it merely it stands for the proposition that rights that have previously accrued under a predecessor's collective bargaining agreement can be enforced by the subsequent union. So
Why? Why should we not extend it to this gap period that Justice Gaziano was talking about?
because the termination of the relationship terminated the contract.
But tell me more about 10A5, because you started talking about 10A5.
So
and then-
10A5 is the statute under which the vaccine mandate case you just heard it was argued. So
I mean, let's not talk about that case. Let's
Right, no, I
talk about
understand.
what happens under 10A5. You were suggesting that the terms and conditions of employment continued and were required to be continued under 10A5, or did I mishear you?
So, and I just want to clarify when they are required to be continued. So if we take, for example, the situation of a newly organized workplace. So there had been no union at all. A union organizes a collection of employees. There's an election, At that point, once the union is certified, once the will of those employees to be represented by that union is certified by the Department of Labor Relations, the employer has an obligation to maintain wages, hours, and terms and conditions of employment at the status quo.
That's really easy. The hard issue is the one we have to deal with.
I agree.
Which is, okay, these employees were represented by a collective bargaining, they were represented by a union.
Yes.
That union achieved a collective bargaining contract for them. And they're not going non-union. They're just switching union representatives. So they like unions, they just didn't like that union. And then you're saying that all that they negotiated in the past, which would have continued, right? Again, no matter what, if they hadn't changed representatives and that notice that we talked about earlier were given, all those provisions would be in effect, right? The only difference now is they change unions, and you're saying now it's the goodness of their heart that keeps those in effect.
I'm saying
But it's
that-
really
so if-
10A5 that keeps them in effect.
Exactly. If there is no gap in representation, it's 10A5 that keeps them in effect.
There is no gap in representation.
Here, there's a gap in representation.
There's a change in union representation.
As of January 8th, the Teamsters have disclaimed interest.
They've disclaimed interest because they lost.
They hadn't lost. The election was held subsequently.
They were
So
about to lose. There's a union campaign.
If they hadn't disclaimed interest, they would have been on the ballot. The employees would have been offered the Teamsters as a choice. They weren't even offered the Teamsters as a choice. And this may be a case of sour grapes. The Teamsters, and we may find their behavior in walking away from this bargaining unit reprehensible, but it's not unlawful. So for example,
There's nothing reprehensible about it. The union, now we have a different union, and the question is, does 10A5 preserve, and the whole sort of thought process on continuing contracts when they expire, does it extend here? And does it include the grievance procedure, right? That's the issue we have to deal with. And I understand it's complicated, because even under the federal law, they're all over the place.
so I would distinguish between grievances and arbitration. So under Litton, for example, Supreme Court case, the court distinguished between grievances, which the employer is required to meet and negotiate over because of under the cognate federal statute, section 8A5. Those were distinguished in Litton from arbitration. So the employer was required to meet and discuss grievances, but not arbitrate them because there was no arbitration clause in effect at the time of the disputes arose.
Why is
You're
the-
saying the CBA continues under all of its terms except for the arbitration clause because you can only be bound under Linton to arbitrate if you have an existing contract.
Except that it's not the CBA that extends. It's the terms and conditions of employment.
Which
absent the
are
CBA.
written down in the CBA.
So they're very closely related. There's no question. But the cause of action here would not be a violation of the contract if we didn't do that. It would be a charge of prohibited practice for failing to bargain. Okay, so that there's a difference. It's a different cause of action related to changing terms and conditions of employment. If there's a contract, there can be an arbitration. If there isn't, and there's a group of represented employees, there would be instead a charge of prohibited practice for failing to bargain over a change. I do want to focus more on the impact of the
Sorry.
disclaimer of interest.
Yeah, it's 3 minutes over, so you don't have time.
All right.
Do you have it in your brief? I'm going to assume it's,
Please, and I would rely on my brief. Thank you very much, Your Honors. I appreciate your time.
thank you. Okay, Attorney Horgan.
Thank you, Madam Chief Justice. May it please the court, Tom Horgan on behalf of the NEPBA. I'd just like to start with addressing the presumption of arbitrability in the sense that it's both recognized in the Massachusetts and in the federal courts that there's a presumption that an arbitration provision should be arbitrable, and in order to arbitrate should be upheld unless there's a finding there's not any reasonable or susceptible interpretation that can be enforced to cover that dispute. And that's heightened in the sense when we have a change in union representation and or expiring contracts.
But so that's tied into why the city, you say, is wrong, that the January 20th disclaimer didn't terminate the collective bargaining agreement.
Correct, because the contract.
The why in there, I want you to tell me why. Why
Because
did-
the contract was always in effect, it was never expired. And that goes back to the intent of the parties. The city of Chelsea, when they negotiated this contract, they didn't include language that this could be unilaterally terminated. They didn't include language that a successor could not step into the shoes of the
Well,
predecessor.
they didn't include an evergreen clause, though. This is a somewhat unusual provision. It says basically somebody has to ask to continue it, right?
Correct, but it can only be continued, it can't be unilaterally terminated, unlike some agreements that include that type of language. And just, I'd like to point to the Cincinnati newspaper case, U.S. District Court case, which I think is on point with the facts that we have in front of us. In that case, you had a contract that was continued past its expiration date, per the language in the contract. There was a newly certified representative. After that certified representative was certified, the events giving rise to that grievance occurred. And the court said, in that situation, the successor union could still enforce the terms, even though, including arbitration, even though the events occurred after the certification, because the new successor union had assumed the agreement voluntarily.
The Cincinnati newspaper case is by who? By which court? Or
I believe it's U.S. Appeals Court,
which one?
Sixth Circuit.
Sixth Circuit, yeah. Although, from what, I think I've read that case, there's something different about that case, right?
They have the contingency that the successor union has to assume the contract. They have to take steps to either notify the employer that it's their understanding that they're a successor to the agreement.
Right.
And take other steps that are aligned with the contract, either filing a grievance or a motion to compel, as the case was here.
This is a little tricky, though, right? So we're in this period post, the old unions left and said they want nothing to do with it. The new union stepped in. Why, the terms and conditions are preserved, but they're preserved by 10A5, right? They're not, it's not like the contract is in effect, right? Talk about that, because that's where this gets novel.
Right, I think my brother pointed to the case in Lytton, and the difference in Lytton was that the contract had expired, and that wasn't in dispute. And so the terms and conditions after the expiration, the terms and conditions, the grievance process, not the arbitration provision, but that all continued. That became the status quo.
But so he says not the arbitration process.
Right.
That suggests you agree with him. I take it that's not what you
If
meant.
the contract is deemed to be expired, the arbitration provision, absent clear and unmistakable language in the contract otherwise, yes, the arbitration is a matter of contract.
So then talk to me about that. Why is that not binding here then?
Because the contract never expired here. The only reason that the city is arguing that the contract expired is because the employees of the union enacted on their statutory right to choose freely choose a representative of their choice. And that is the reason why the contract is expired from my brother's standpoint.
In
But
the
to penalize-
in the gap period, with whom is the contract?
Well, it's just a status quo. Everything has to freeze at that point because until the board determines who the majority representative is, they don't want any prejudice to take over the group until that decision is finalized.
But under what authority is that? 10A5?
10A5
So the answer is 10A5 for us?
would preserve the status quo in that situation while we wait for the board to make a determination on the representation petition.
Hold on, but again, that's easy. It's the hard part is once you've got a new union. Once you have a new union in place and they're bargaining, does 10A5 preserve the terms and conditions, including the arbitration? What keeps everything in place? Because you both seem to agree that 10A5 preserves everything else but the arbitration. You seem to be suggesting that the contract remains in place and that preserves the arbitration. I'm just getting lost here, and I also know that the NLRB has some very odd decisions on this, so I'm not sure. What preserves the arbitration? Is the arbitration clause preserved by 10A5 or not?
It is, in that, while the parties await to see what the DLR does with the representation, until they have an election.
Again, we've had an election. This is very simple in that period. What happens is when we switch union representatives, that's where this gets difficult, where we switch representatives and we're negotiating a new contract, right? That's the period we're in. That's when all this occurs, right?
Right, but the contract that initially was signed by the Teamsters never went out of effect. It was still in effect.
He says it's not, and you say it is.
It is.
Can you tell me, well,
The schoolyard argument.
tell me which, I'm gonna give you a multiple choice option here. So when you say it is and he says it isn't, is it, hold on.
Okay.
Is it Article 25 of the CBA? Is it Watertown? Is it 10A5? Is it the city solicitor's email? Why do you say it is?
So it's Article 25 because the city in the Teamsters negotiated that provision to allow all provisions to extend. And then they did in fact extend. Then we had a certified representative, a new certified representative. And at that point, I would point you to the Cincinnati case that says employees have a choice of free representation. They can elect to utilize that and choose a representation from here to here, whether the employer assents to it or not.
And when you said, they didn't extend, but they made that decision, are you saying that's the city solicitor's letter?
Yes, and I don't believe that's in dispute. But the Cincinnati case says you cannot void a contract merely because the employee chose to a new representative. And so the contract would have been in effect, but for the change in representative, in the Cincinnati case says that's not true. It doesn't void the contract.
And so 10A5 wouldn't, 10A5, what is 10A5's role in that? 10A5's role is just protecting the change in representatives, or does 10A5 also help keep those conditions in place? Because otherwise, by definition, you're penalizing the change of representation.
Right, it essentially freezes the terms and conditions, including the arbitration at that point, until the board can determine who the exclusive representative is. So that this case, the Teamsters disqualified interest, but not in all cases that's true. And sometimes you might have competing unions fighting over a group.
Right, but the feds are all over the place on that, right? Have you read the NLRB decisions? So we have some NLRB cases. We have at least two that are of some relevance here. There's this Arizona Portland Cement and Children's Hospital. Have you read these two cases? Mm-hmm. Okay, so one of those cases says that the old union would continue to represent, would continue to do a grievance even though you've changed representatives, right? And then the other one, they don't sort of carry over the obligation, right? It's messy. I don't know if it makes any sense.
But I believe with the NLRB cases, the expiration that was not in dispute. The parties weren't disputing the fact that the contract had expired. Then the issue became, what were our obligations, what arose under the contract prior to expiration?
But they don't sort of freeze everything in place automatically, though. Like the question I asked you earlier, is the freezing necessary to prevent punishing a change in union representation? You said yes, which I thought was the right answer, but that isn't necessarily the way the NLRB does this, because otherwise that decision in Arizona Portland Cement doesn't make sense, does it?
No, my understanding is they do freeze. They have to freeze the terms only but for to protect the employees in that situation.
But they don't, but there they say there's no grievance. They say there's no arbitration required in Arizona Portland Cement. They say, even though they say this is a post, right? Isn't it? I can't remember the facts, but it seems like they suggest that if you change representatives, I guess it's easier because they say you change representatives, but the old union is going to do the grievance under the old But they leave the suggestion that the new union would not be able to do something afterwards, don't they? You don't read it that way?
They don't.
Okay.
No, I read it as those contracts, there was not in dispute that it expired, and then the only question became whether the incident that they were looking to grieve arose under the contract before it expired.
What is your understanding of what the NLRB's rule is for exactly this situation, where a contract was in place, it's in that evergreen or it's in some kind of the contract was in place, but it had expired. And then there was just what we have, some kind of notice saying you're going to continue this, and then an incident happens, and after that change, do you say the feds have decided this issue, that the new union gets to do that under the old contract?
If they determine that the incident that gave rise to that grievance in particular
Occurred after the change in representation,
No,
but prior to the negotiation of a new collective bargaining agreement?
I have not seen any NLRB cases that have held that position.
We can't find any either, so you haven't seen them do
No,
this yet?
only prior to expiration.
Okay,
Where there'd be-
all right, so.
The only case that I can point to, the General Teamsters case, which is referred to in the Cincinnati case. Those two cases are the ones that have allowed in a successor union to grieve and take to arbitration a grievance concerning events that occurred after the certification. And again, Cincinnati case is very clear that the employee has that right to choose that representative, and you're really punishing them if you don't allow them to grieve in that situation, because they're not going to switch representation if they know that their contract could potentially be voided.
Right, that's right. That seems to be the guiding problem for the city of Chelsea, which is if you don't allow this, the change in representation has put people in a worse position.
Right, and we're dealing with 911 dispatchers, emergency personnel.
Well, they're still allowed to grieve, right? I mean, the position is not that there isn't a grievance procedure, it's just not subject to arbitration.
Right, but the problem with that is they can grieve it, and the same individuals that are issuing the discipline are going to be making the final decision on that discipline. And so that becomes,
You could sue them in court though, right?
Absolutely.
So that's instead of having arbitration decide this, you end up in court.
Right, so the difference is, do you get an arbitrator or do you get a judge?
yes.
And that, you say, is putting the employee in a worse position.
Especially when the city clearly negotiated language that allowed for the arbitration of grievances post the expiration date of June 19th and to continue indefinitely. If that was their intent, if their intent was, to either not have a successor take on the agreement, they could have contracted for that. And I think the U.S. Supreme Court in the Knoll case speaks to that. They look at the intent of the language in terms of determining whether or not, the parties intended to grieve specific disputes. And here I think we have a clear, a broad arbitration clause that continued, and it continued past post-expiration, and was in effect at the time that the events here in February 1st of 2021 arose.